So good morning, Your Honors. Before I forget, I would like to reserve 5 minutes for rebuttal. I'm here today on behalf of the prison officials who were denied qualified immunity. And really, I'm here to focus on an issue that I think is of vital importance to the ability for prisons to operate. And I'm here because I want to urge the court to reject the idea that transferring even sick inmates into a prison, that can support a prison correctional officer's constitutional claim.
Were there negligence claims brought here?
Your Honor, below, as far as state law tort claim, I don't believe that there are tort claims.
Do you agree that there would be state law tort claims here?
Certainly, Your Honor, there would be many different state law claims that could be brought.
And if those had been brought, we wouldn't be here. Because you wouldn't be entitled to qualified immunity and that'd be going forward. The reason we're here is because they've turned this into a constitutional case solely, is that right?
Well, it is. It's not solely a constitutional case. The case will proceed against CDCR as an employer under the ADA, the Americans with Disability Act. So you have a specific scenario where an employee can still sue the CDCR.
There are ADA claims, but there's no negligence claims.
That's correct, Your Honor. And there are claims that go forward in state court for based on COVID in employment. I think that the reason that this is so important is because transferring an inmate, right, sick inmates into a prison, that happens every day. Every day, inmates enter and exit prisons. They're incarcerated. They get sick. Someone is going to have to deal with those sick inmates.
Okay, but right? Fair enough. But right. This is a different context, right? I mean, we all knew, we're all vividly aware of what the pandemic did. Here, the question seems to be,
right,
the specific. These facts are not good for your client.
No, they're not, Your Honor.
No, when the facts are bad, argue the law. So go ahead. But you would agree that maybe they shouldn't have disregarded every single piece of advice that they got.
Well, Your Honor, I certainly would say that the allegations in the complaint are about as bad as you could try to draw this up. And leading to what Your Honor said, I do think that this idea that it was such an epic, horrible thing that we should create this new exception to the law really shouldn't hold here. And it's for a couple of reasons. One is that every correctional officer, right, dealing with those inmates, how about the officers who were at CIM, at the outbreak, who are dealing with it? There's always going to be an ability for officers to say, you could have put them somewhere else that was safer, not here. That's not reasonable.
Well, I have a question. Is it just about where they put them? I mean, weren't there, as Judge Nelson made reference to, a lot of recommendations about distancing and masks and how you were treating the prisoners, the things you were providing to the guards? Isn't it more about those requests being ignored than just about the transfer?
So that's a critical point in this case, right? Because you do need to address the transfer on one hand, this idea of bringing in people with hepatitis, with Ebola, anyone being brought into a prison from the post-transfer conduct. When you just introduce sick inmates into a prison, which, as I said, happens all the time, that's creating a generalized risk. That is going to be a generalized risk that is elevating an inherent risk that every officer already has by coming to work in a prison, interacting with inmates who can't be sent home when they get sick. So that's the transfer. As far as post-transfer conduct...
Sorry, can I just pause you there? So what case says that transferring someone with Ebola into a prison and not isolating them is okay?
Well, certainly, Your Honor, there's not a case that says that. But what you do have is cases that say things like making medical decisions which increase the inherent risk to correctional officers, making medical decisions with how to treat inmates, that does not create a constitutional violation. That's the key. Is it an inherent risk in a government employee's job so that they know going in, this is what I'm dealing with here? And the complaint itself look, we can't deny it's tragic that this is the one employee who died as a result of this transfer. It is tragic. The issue here is that from a constitutional claim perspective, the complaint alleges some officers didn't come in. He did. And what you need to recognize here, I think, to make this work is that you have to have a particularized danger against a specific employee. And that's going back to what Your Honor said after the transfer now, right? You have the inmates who enter the prison. They're sick. Well, the guard who's at the front gate, they're not really engaging with those folks. So they just have this general amorphous generalized danger because you have introduced sick people into the prison. But now what about the person who, specifically is engaging with those folks?
And driving them to the hospital.
Okay, yes, Your Honor, driving them to the hospital. That, unfortunately, right, yeah, okay, that's particularized. It fully is. However, what was his job? His post, his assignment was to drive sick inmates to the hospital. Now, if he did not get protective equipment, that's a tragedy and that sounds wrong and maybe he would have other claims. But even then, I think the court has to look at Collins and look at Coucher.
Wait, look at what? Sorry, what?
Pardon me, the Collins case, where I think that the law for state-created danger cases for employees, I think what the law is that if it is an inherent risk, okay, like being exposed to sick inmates at work as a correctional officer, even if the employer does things that we look back and say, that was wrong, you totally increased the risk there. You should have given everyone respirators. Even so, what I think Collins says, and I think Coucher says, and I think the prison resource allocation cases say, is that that's still not a constitutional violation.
Okay, so what about Pollock? So it seems like what you're saying is someone could just not come to work or something, but Pollock could have not come to work, and our court still held that he had a constitutional claim for the mold in his workplace.
Yes, Your Honor. Now, see, that's a very good point in that if we look at that case with the mold, I think that the critical distinction there that you would say, well, that's why it doesn't apply, is that no office worker has an inherent risk to have to deal with toxic mold. You don't.
Well, he definitely knew. I mean, he was complaining. He knew that he had the risk of toxic mold. It's not like it was a secret.
It might not have been a secret, but yet and still, they moved him into a spot where his job didn't require him to be there, unlike dealing with inmates,
okay,
right?
Okay, so then I guess we get to the question of if it's Ebola or COVID.
Or hepatitis C, Your Honor?
Well, I don't know how hepatitis C works. Maybe
tuberculosis?
Let's stay with Ebola and COVID, sure. Where people are dying and the allegations, I mean, maybe you can show later that they didn't really understand what the medical advice was, or they didn't really understand that washing your hands wasn't enough, or you could do that at trial. But the allegations are that the medical people were saying, if you don't isolate these people, people are gonna die. And that isn't usually the situation in a prison. I mean, you could say people are sick, but this is a worse thing. So what tells us that that's not a different situation?
When I would like to point out what you're talking about now is post-transfer. I'm saying 100% your honors need to recognize that you can move sick inmates into the prison. What you do with them after there, now that's what you're getting to.
Okay, but they brought both, haven't they?
I'm sorry?
They brought both claims. I mean, you may be right on transfer. That but what about once you get there?
Sure. Well, okay, so let's look at what happens afterwards. I think still you have to go foundationally to Collins, right? Because we're talking constitutional claim. In Collins, you had a sewer worker, so he knows his job involves going into dangerous sewers where he could asphyxiate. The claims by his family were that you didn't give him PPE to protect him. You sent him into a particularly dangerous sewer. You didn't give him adequate training. And those things, the U.S. Supreme Court said, you know what? Those, unfortunately, are the inherent risks of what you do. And so I do think here, unfortunately, yes, the fact that when you're talking about managing the resources of inmates.
Increased risk. What do we do with the increased risk that was imposed? Like, you're right, there's inherent risks. But what plaintiffs are alleging is that you increased those inherent risks by failing to take action. And maybe your point is, I don't know, you didn't say it this way, but the Affirmative Act, I guess your point would be the Affirmative Act is moving them into the prison. The rest of it is omissions? Is that what you're arguing?
That's interesting, Your Honor. I hadn't really framed it that way. I mean, I think that there was an affirmative act. Let's just acknowledge that, yes, they knew some of these inmates were sick.
Let's walk through the affirmative acts. Clearly making the decision,
Right.
And I think it's defensible. Like, they had to move them somewhere. They moved them. Okay, so that's an affirmative act, moving them. What are you saying, that there's no other affirmative acts other than that?
No, I'm not. And what I'm actually saying is that the law allows for affirmative actions by prison employers that increase the risks to their employees of inherent dangers. The key, and that, for example, would be the fraternal orders case, right? You have intentional decisions. We're cutting the guards. We're going to have fewer guards. We're going to move them in and have more inmates to deal with. Obviously, that's a resource allocation decision where you are endangering the guards. And because the correctional officers, by the nature, understand the business is to deal with these dangerous inmates, that is not a constitutional violation. It might be a tort claim. You might have other claims, but not a constitutional violation. So there are many affirmative acts alleged. And I think the analysis that has to be applied is, okay, one, did that affirmative act create a particularized danger?
What are the other affirmative acts? I mean, I guess the other I mean, are you saying that failure to test them was that an affirmative act, or was that an omission?
I think that either way, you could frame it either way.
You're saying you win either way. You're saying the court shouldn't grapple with whether it's affirmative act or omission.
I'm not saying, maybe that's interesting. There might be a significant distinction there. I would love to think about that more.
Well,
but what I'm saying is, if you don't test,
and the reason why I say this is you're clearly on stronger grounds when it's omission versus affirmative act.
Well, certainly omission. I mean, not testing. What is that? I mean, what you're basically saying is, okay, we've got sick inmates and we have resources, and we're not going to expend them right now. We're not doing it.
The state-created danger doctrine,
right,
is exactly about being an exception to the idea that omissions don't matter, right?
Yeah, you're right. Well, I'm sorry. That what omissions?
That omissions can't be the basis of a claim.
Well, wait.
That's what the doctrine is. It's when the state affirmatively creates a danger, then you can look at their omissions.
Right. So for example, right, like let's take the Grubbs case, which is so interesting, right? You have a nurse. She works in a prison, right? But there, what you don't have is, it's not, what they did there is they moved in a sex offender who hadn't been programming, and then they told her, we're not going to do that. You've deprived that employee now of the information about, what is my job about? I'm coming to work today. I need to know, hey, is these the dangers that I'm facing today? And in Grubbs, they withheld that from her. I think that that's a critical component. So number one, I think.
And you would call that an omission? And
that certainly could be an omission, still a lie in a sense, right? A lie of omission. But that is a deception, and we don't have that here. Everyone understood, including some officers who stayed home, that you're moving in sick inmates. And then you have the general management of them there, right? Are we putting them outside, or are we putting them inside? I would say that probably that's not particularized enough either. That's just a general risk now you're talking about that's affecting the prison.
Well, but you've already said, I think, that you think there was a particularized risk against this plaintiff because he was driving them to the hospital. So I'm not sure it matters.
Well, okay, let's talk about that, right? That is the nub of what you would say is an individual who is now saying, okay, me, what not sick inmates in the prison somewhere, but like, what am I dealing with? I would say in that situation, you have to look at the following. It's close. I would say it's close, but here's what I would say. You do have someone whose job it was to drive people who were sick to the infirmary. So that is a known risk that he has in that post assignment. Okay. Now, if there were other allegations where he said, hey, I don't have my PPE today, and and you're denying me, and someone says, I don't care, get in that van with that Ebola patient and get there.
Well, isn't he alleging that he was repeatedly asking for PPE and not getting it?
Well, I mean, so I think that maybe that's significant with the omission. That's a resource allocation decision. It's sort of like where someone says, hey, look, you've got a lot of disease at this prison right now. Why don't you use what you know will stop it, which is to treat these inmates and reduce the incident? And the Coucher said, you know what? That's a resource decision that even though it increases your risk. So I think, honestly, when you look at the cases on state-created danger for employees, right, it has to be for government employees, not like members of the public, you need an affirmative action that just changes the general status quo, probably not an omission. It needs to be something that results in an increased or created danger that's not inherent. It's not inherent to the job already, so you know, right? COVID, I mean, it's sad to
I'm
say.
sorry, let me interrupt you because you're using up your time and I don't know if
Yes.
you want time for rebuttal.
Well,
So-
I would just for one moment, Your Honor, all I would like to say is the medical officials, that's one of the things is that there's no case that talks about how medical officials are supposed to stop when they're trying to, or consider the officers with respect to how they're treating their inmates, okay? So I just would like to say that. And if I could have.
I'll still give you 2 minutes for rebuttal, but let's hear from the other side.
Thank you very much, Your Honors, I appreciate it.
Morning. Let me start by just addressing the question. There are state law torts were brought, particularly a California Bain Act claim. The district court dismissed that claim. That was the only one that was brought. And there
And
is
that's
no,
not up, well, I guess it wouldn't be because it's not final judgment yet.
we can't appeal that yet. And there's no separate state court case. I just wanted that to be clear.
I figured. So we're up on constitutional issue. I think what would be helpful, I mean, there's a lot of different ways we could approach this, but I'm interested in, both the deliberate indifference and then the qualified immunity prong. And deliberate indifference, you have to have both, do you agree that you have to satisfy both the objective prong and the subjective
Yes.
prong here? And why do you think that you satisfy the subjective prong in this case?
The subjective prong is knowledge of the risk. And there's really no dispute that all of these officials had subjective knowledge of the grave risk that COVID posed.
Well,
at this
is
time.
that true? I want to push back on that. And maybe that just pushes this to a factual question. But that's what seems to distinguish this from Ebola and, a bad flu or hepatitis. Those were known risks. I mean, we were in a situation here where no one really knew what the risks were, and the officials were changing their recommendations all the time. So is it fair to say, well, these officials said to do this on this day, and the fact that you didn't do that shows a subjective intent? Because we don't know whether the officials, 2 months later, the officials were saying, oh, we were wrong about that. We've got new advice now.
The subjective part of the deliberate indifference test goes to the subjective knowledge on the part of the official of the danger.
Well, that's my point. Could you have a subjective knowledge in this circumstance with an outbreak that is so new that the science just isn't there to know what is causing it and what's not causing it?
We don't have to go based on our memory of what it was like on May 30th, 2020. It's all pled in the complaint. And by that time, as the complaint pleads, it was well known to everybody. The governor had declared a state of emergency. All the counties.
But that's my point. Just because a government official says that, I don't think you can say that just because you disregarded what a government official says the risk is, that's enough.
It certainly creates questions of fact, and the issue here is, was it plausibly pled at this time? In addition...
Yeah, can I just pause you there? Because
Yes.
I think we don't really have to decide today what the officials really understood. We have to decide whether your complaint alleges that they understood. And I think the complaint says they heard all these warnings, they understood. Now, maybe they also heard other things and it turns out they didn't understand, but that's for trial, right?
Exactly. And just two more little trills on that. One, the Plata court, which basically oversaw the medical receiver, wrote an opinion about 2 months before this happened saying no one disputes that COVID poses a serious risk of harm and potential grave death. Number two, in the cases afterward that we cited, there's a California Court of Appeals case, and then a follow-up to that. One of the defendants here, Warden Broomfield, admitted subjective knowledge of the risk. So this is the kind of evidence that's going to come out eventually.
Who admitted, back up,
Acting Warden Broomfield, he's a
Okay.
defendant here.
and he acknowledged
Yes.
subjective, okay.
Yes.
So, can I ask you about qualified immunity? Because I mean, some of my concerns bleed over, I think, into qualified immunity where, the cases that are being relied on, I mean, where is the case? I guess you cite Grubbs and Pollock for this idea that, this was clearly established. But I'd just be interested in why that is so clearly established under that law. This does seem like a unique circumstance where, they didn't know how, there wasn't clear understanding of how to proceed.
you can pretty much define what's going to happen in a qualified immunity decision by how narrowly or broadly you define the right at issue. The Supreme Court has explained it can't be too broad. So too broad would be something like there is a right to be protected from a state-created danger. That's too broad. Too narrow would be the way the defendants frame it, which would be basically they're demanding a prisoner transfer case in a pandemic. That's too narrow. We're never going to have that. And I think the way that the clearly established law framed it was, number one, it was clearly established that the state-created danger doctrine applied in a government workplace, including in a prison. And number two, it applied where the state-created danger was a condition that created risk of disease. In fact, death-causing disease. And I think that's close enough. And I would point out, this is not about a generalized danger that all prison guards normally face in a prison. Even during COVID, during a prison transfer, prisoners can be transferred in a way that doesn't increase the danger of a normal transfer of a person who might have COVID. Here, the way they did the transfer, the manner of it, was unique and created the danger at the beginning here. For example, as the state OIG found, nurses on the ground at CIM warned these very defendant government officials, what about safety? These people haven't been tested. We don't have time to screen everybody. We're packing them on buses in excess of our own requirements. And so the way they did it to start with created unnecessary and new danger to the guards at San Quentin. The chosen destination of San Quentin.
Have you read my recent opinion in Sinclair?
Yes.
Okay. I'd like you to address that, what the differences are there, because in some ways it seems somewhat analogous, but I think there are some differences, and I'd be interested in your view. I was surprised that nobody wrote in a 28J letter. So
well,
maybe you didn't want to call attention to potentially bad precedent, but I want to hear you.
I knew I didn't need to do that because you wrote it or you were on it. and number two, I did think it's distinguishable. But first of all, I want to point out the defendants did not raise this argument on appeal, and they've waived it. It's not in their briefs. They raised it
Which
below.
argument? That there was no state?
That it was not particularized to this particular plaintiff.
I see.
They didn't raise it.
So you think that we don't even need to go there?
Exactly. But if you want to go there, it's fine, because as the district court found, Judge Breyer found, that it was a particularized risk to correctional officers in San Quentin, to the class of people that our plaintiff was a part of. And it was obvious that this class of people was at particular risk. And just like the group in the case that you just did, there it was a member of the public that entered a risky zone. And I believe that your court distinguished that from a previous case where residents who were in a zone where danger was created might have had such a claim. And so this is more like...
That's the difference here. So you think that this is, the prison aspect of it really brings this into, is it the responsibility they had over the prisoners that distinguishes this from Sinclair?
It's the responsibility, the constitutional responsibility, not to create unnecessary risk for people who work for them in their workplace. And that's the prison guards in this context.
And this isn't a class action though, right? So really, it's just, he had an even bigger risk than the general guard because he was driving them to the hospital.
Yes, and he had pre-existing health conditions that they knew about. Yes. So, I just wanted to be really clear, it was not an inherent risk of the job. This was above and beyond, and this was created and sustained. So not only after creating the first risk, that was bad enough, but then they exacerbated the risk over time by ignoring all these public health warnings, including from the receiver's hand-picked experts, who made a number of specific recommendations that were all ignored. The defendants...
And so can I get back into how we define how do we define this for purposes of qualified immunity? At what point does the risk, I mean, because you could have risks that run the gamut, is the fact that 1 out of 100 die, 1 out of 1,000 die, 1 out of 1,000,000 die. At what point is that so clearly established that you would have a claim here? Or it doesn't, you would have, sorry, I phrased that wrong. Not that you would have a claim, but that they would not be entitled to qualified immunity.
The state-created danger claim does not require risk of death. It just requires risk of harm. And I think that, at minimum, was...
So you would say any risk of harm gets them out of qualified immunity grounds here?
It states a state-created danger claim. That's what the claim requires. Risk of harm that the state created that then officials ignored. That's what gets you the claim. And that's what, of course, Grubbs and
my concern with that is you sort of are saying that anytime you get to across the state-created danger threshold, there is no qualified immunity.
No. There's no qualified immunity here because there was a prior case dealing with government employees and where the risk was a condition in the government workplace and the risk was a disease-causing agent. That's very close to the situation.
You're saying the mold case this is tantamount to the mold case.
Right. Now, as we mentioned in our brief, there's a Seventh Circuit case that specifically says, excuse me here, for purposes of qualified immunity, the legal duty need not be litigated and then established disease by disease or injury by injury. And then this court wrote something similar in Russell versus Lumitap, which I believe was another one of your cases, Your Honor. And in that case, this court pointed out, it's not necessary to have a case involving a heart attack, a case involving appendicitis, or a case involving a bowel obstruction for a 1983 claim.
But that does seem a little bit different. I mean, those are all medical, issues, and I agree with that. But I mean, there's something different about mold in a workplace versus an outbreak that is new.
Well,
and that's what I'm grappling.
We don't need a prior COVID case, and even the defendants.
Well, I agree with that. I'm not. I think if we were to write a rule that said, "Oh, you have to have a prior COVID case," then I think we would run afoul of Russell versus Lumitap. But it does seem like there is some difference here between, I mean, because under your theory, if there's a new disease and we just don't know what the ultimate outcome is, then you would always have a state-created danger.
That becomes a question of fact about the subjective component.
Okay, fair enough. It does. But they would never be entitled to qualified immunity in that case because you would be in here arguing, hey, there was a risk. There was a new disease. There was a risk. We don't have to quantify how big the risk is.
Well,
there was a risk.
As long as it's properly pled, yes. And as we've got the strong facts here, and so we've pled them. And I think that's all this court has to look at this point. Is it properly pled, adequately, plausibly?
So you're saying they might be entitled to bring up qualified immunity at the summary judgment stage again, but you should win on the pleadings.
Yes. Yes. So let me just close. The Supreme Court has said repeatedly about qualified immunity. The driving force behind the creation of qualified immunity was a desire to ensure that, quote, insubstantial claims against government officials will be resolved prior to discovery. Now, it's interesting here, in the defendant's reply, they do not even contest the first prong of qualified immunity. And under the strict requirements for a state-created danger claim that this court follows, that means that the complaint plausibly pleads that the defendants affirmatively acted to cause a new or increased danger that was actual and particularized and that was known or obvious with deliberate indifference to the rights and safety of correctional officers like Gilbert Polanco, who was foreseeably injured by that state-created danger. So the defendants do not contest that the complaint pleads all of that. And any state official who kills someone by their state-created danger, doing all those things, should have a very steep hill to climb to get qualified immunity. This is not an insubstantial case. The state OIG called the result of the defendant's decisions a public health disaster at San Quentin. A legislator called it the worst prison health screw-up in state history. And based on Grubbs, Pollock, and over 30 years of state-created danger cases, these defendants had fair notice that they violated Gilbert Polanco's rights by their deliberate indifference to the danger of disease outbreak they created and exacerbated at his workplace that was so extreme that it foreseeably led to his death. Thank you.
Thank you. We'll give you 2 minutes for rebuttal.
Thank you. Well, let me cut to the chase. And I think that really, if we get to the second level, about whether or not, the officials were on notice. Yeah, you don't need a case that said COVID, but you need a case that has some elements that none of the current cases, Coucher or Collins, have. You would need a case that tells you, how do you balance the risks to the San Quentin officers by bringing in these COVID sick inmates compared to the risks of leaving them at CIM, where there were correctional officers who had families who had to deal with them. Where do you balance? How did the officials know how to balance when the receiver at least acquiesced, if not approved? I think that it's approved, but at least acquiesced with the movement to San Quentin. And that the whole motivation of the transfer, we all understand, was to save inmates who were in an outbreak.
So couldn't we, though, think the transfer itself might be justified, but then the omissions after, with not quarantining them, not giving the officers masks, not giving the prisoners masks, all these other things are the omissions that the state created danger doctrine allows to proceed now?
And I think why that doesn't work, Your Honor, is that even with these conduct, allegedly not giving masks, moving the inmates, not testing them, all of those things, there's always going to be an incremental risk to an inherent danger, right? You know you're going to be exposed living in San Jose, where every day people are coming in. What about vaccines, Your Honors? What about the fact that the COVID inmates are going to be moved in? Well, what about an officer who chose not to get a vaccine, right?
Well, there were no vaccines at this point.
There were not. It was at the beginning of the pandemic, so no one really knew. Things were changing all the time. You're trying to figure out, how do we manage it? Some people were telling them, we'll do this, that, or the other thing, but that's not like a law that was saying you must do it. They're still at that moment in time, especially the medical officials trying to figure out how to handle these folks. There's no case that told them this is where it's too much. And that's really what this is about. This is about might. It seems bad, but there's no standard. So Your Honors would need to explain how Coucher and the Mole case and these things created some sort of a balance and allowed people to assess risks. And I think since that doesn't exist, I think that lack of cases mean qualified immunity applies.
Thank you both sides for the helpful arguments.
Thank you very much.
This case is submitted.